Judge Fine ordered the state to hand over the search warrant by January 14th for Melly's defense lawyer's Apple account. And take a wild guess if the state handed it over. Of course not, because they filed a memorandum of law and a protective order request. The state basically asserts that Raven Liberty can't be Melly's lawyer anymore, and they straight up disobeyed the judge's order. So he's going to be livid. I'm going to read the full document here. Hit subscribe. Here we go. Our first thing we got here states a memorandum of law regarding attorney conflict. On December 27, 2024, the defendant filed a motion for hearing to determine potential conflict. In this motion, it states the defendant's attorney, Raven Liberty, was informed on December 18, 2024 by Apple that on December 13, 2023, that her Apple account information had been provided to the Broward Sheriff's Office pursuant to a search warrant. Monday, January 6, the Honorable Court heard the defendant's motion, and the court ordered her to hand over the search warrant. That's what he did, right? On January 6, 2025, the state filed a motion for rehearing reconsideration to compel disclosure of Apple search warrant related to attorney Raven Liberty. Within this motion in paragraph 11, the state mentions that regardless of the details of the investigation, Ms. Liberty has the ethical obligation to withdraw even if the defendant were to waive the conflict. So straight up, the state is saying she needs to withdraw and not be his lawyer anymore. Kind of crazy, right? In U.S. v. Pizona, 2006, the court held that if the attorney suffers from an actual conflict so severe that it impedes effective assistance, counsel should be disqualified notwithstanding defendant's desire to waive. If the activity for which the attorney is investigated is substantially related to the charges against the defendant, disqualification is necessary, notwithstanding the defense waiver. At one point, they said it wasn't related to the charges against the defendant. Stewart even pointed that out. He said, is it related or is it not related? To the judge, I don't know if we ever got an answer or not. Well, no, she said it was related to Melly, but not the other charges. It's about the witness tampering. On Tuesday, January 7th, the Honorable Court entered a written order ordering the state to provide a copy of the search warrant to the defendant to determine his potential conflict over the state's objection. Yes, and you should hand it over, right? Let me guess, you're going to find some reason not to, eh? Over the defense objection, this Honorable Court ruled it would review the search warrant camera for potential redactions. During this January 7th, 2025 hearing, this Honorable Court spoke to the defendant about how it was his decision alone, to determine whether to keep Ms. Liberty as counsel despite the conflict. Oh. It is not the defendant's decision. Interesting. Curveball. They're saying it's not up to Melly, but the judge was saying it is. All right. I didn't expect that. The United States Supreme Court has recognized that the Sixth Amendment right to counsel is circumscribed. I thought that was about to say circumcised, and I was like, what am I reading? In certain situations, see Wheat versus U.S. a 1988 case explaining that the Sixth Amendment right to counsel is premised on the right that a defendant is entitled to receive a fair trial through the adversarial process, and the relationship between the counsel and defendant must give way to that right. So this whole paragraph is basically the state trying to get around Melly's Sixth Amendment right. That's what you just read there. They're saying the Sixth Amendment right to counsel is limited, and they cite whatever this case is. So there we go. The United States Supreme Court also explicitly rejected the argument that a waiver of the conflict cures a violation of the Sixth Amendment. To the contrary, courts have a legitimate interest in ensuring the criminal trial is conducted within the ethical standards of the profession. Wheat at 161. Therefore, the rules of professional conduct, including those rules of the State Bar Association, which govern attorneys' conduct, are of paramount importance and should assist in informing the judiciary about how to proceed. So now they're bringing up the State Bar Association, hinting that if Raven Liberty doesn't withdraw, she can get in trouble with the state bar, right? They're trying their hardest to get Raven Liberty off this case. That's all I'm seeing here. At issue here is alleged that the alleged criminal conduct involving Raven Liberty, one of Demond's 4 attorneys, clearly after reviewing the search warrant and camera, there can be no doubt that an actual conflict is present, squarely involving the personal self-interest of Miss Liberty. Moreover, if this alleged conduct, if true, involves multiple violation of the rules regulating the Florida bar. I knew it. Yep. They don't even want Raven Liberty to be a f***ing lawyer anymore. Or at least they want her to be punished for whatever she did, or they're accusing her of doing something with the witness tampering. Citing a 1993 case listing numerous rules involving dishonesty and criminal conduct as examples of unethical conduct prohibited by the Florida bar. 60% of you aren't subscribed. Come on, hit the subscribe bell. The 4th District Court of Appeals has also recognized the superior authority and insight inherent in the trial court's purview to reject a waiver of conflict. Court's authority to reject a defendant's waiver of attorney conflict based on counsel's prior representation of a state's witness. In fact, the 4th noted in a footnote that if the lawyer's conflict encompassed counsel's self-interest, a waiver is precluded as a matter of law. Therefore, the 4th DCA approved of the rationale in United States v. Fulton, where the conflict involved allegations of criminal conduct by defense lawyer, regardless of whether the lawyer is ultimately found innocent. So the 4th DCA doesn't care if the lawyer ends up being innocent or not. This was all worded very strangely. I can't even dumb that down. Okay, here we go. In Fulton, the court stated, second, even if the attorney is demonstrably innocent and the government's witness allegations are plainly false, the defense is impaired because vital cross-examination becomes unavailable to the defendant. Ordinarily, a witness's blatant false allegations provide a rich source for cross-examination designed to cast a doubt on the witness's credibility, but when allegations are against a defense attorney, this source cannot be tapped. So this has to do with witness credibility and cross-examination and bullshit like that. The trial court is obligated to protect the truth-seeking function of the proceedings by considering considering if the defendant has effective counsel, even where defendant wishes to waive the conflict. State hereby submits this memorandum of law. So it sounds like the state is just trying their hardest by citing cases and 4th district rulings that basically say Raven Liberty is not allowed to be Melly's lawyer no matter what. So they're trying their hardest. Where's the fucking search warrant? Have they handed this over yet? That's the real question here. Oh boy, here we go. State's motion for protective order. On December 27th, defendant filed a motion for hearing to determine potential conflict, blah, blah, blah. State hereby requests this honorable court enter a protective order restricting the disclosure of the search warrant, whether redacted or unredacted, to anyone outside the defense team or defendant due to the nature of the investigation and due to it still being a pending investigation at this time. I'm starting to hate Miss Alexander Buckaloo, dude. What? It's a search warrant. How is this going to fuck up an investigation? It's already a known thing that her phone is being searched. Have you ever signed up for a subscription and forgot about it, and next thing you know, you're getting charged for it month after month? I just learned that 85% of people have at least one subscription going unused each month. Thanks to Rocket Money, I can see all my subscriptions in one place and cancel the ones I'm not using. And now I'm saving more money than ever. Rocket Money is a personal finance app that helps find and cancel unwanted subscriptions, monitors your spending, and helps lower your bills so you can grow your savings. You can easily create a personalized budget with custom categories to help keep your spending on track. And you can see your monthly spending trends in each category to know exactly where your money is going. You can get alerts if your bills increase, if there's unusual activity, or if you're close to going over the budget. Rocket Money will even try to negotiate lower bills for you. They automatically scan your bills to find opportunities to save. Then you can ask them to negotiate for you. They'll deal with the customer service so you don't have to. Rocket Money has over 5 million users and have saved a total of $500 million in canceled subscriptions, saving members up to $740 per year when using the app's premium features. Cancel your unwanted subscriptions and reach your goals faster with Rocket Money. Go to rocketmoney.com/cuff today. That's rocketmoney.com/cuff, rocketmoney.com/cuff. Thank you. Here's the rest of the video, boys. Denying such a protective order would greatly impede the current investigation, allow suspects to avoid apprehension, and or allow for destruction of evidence. I don't understand what the state is doing here. This makes no sense. There are a litany of cases dealing with the courts requiring the state to produce information related to an ongoing investigation. In Barfield versus City of Fort Lauderdale, the court held that under Florida law, active criminal investigation information is exempt from public disclosure until the investigation is concluded. As discussed, Florida Pub, 1998 case, an executed search warrant and accompanying material is exempt from discovery and public records law pursuant to section blah blah blah. Okay. As such, the state requests such a protective order preventing the dissemination and or discussion of the Apple iCloud search warrant regarding attorney Raven Liberty with anyone outside the defense team of lawyers. I am mind blown. There is no way this judge is not going to be pissed about this, right? I got to see what people were saying on Twitter about this. He ordered her to hand over the search warrant yesterday, and she didn't. She just requested a protective order. So she disobeyed a court's order. That's what that sounds like to me. Wow, really seeming like they're doing all this in effort to punish Melly even more because they figured he wouldn't let her go as his lawyer. Honestly, I thought he should get rid of her. I kept saying that, but I don't think he's going to get rid of her. So they're just predicting that if Melly doesn't get rid of her and he just waives a conflict and he's like, yes, I'll let her be my lawyer still, that she's required to withdraw. Judge going to be mad. Oh, here we go. Perfect tweet right here. State of Florida willingly and intentionally defying a court order. Hopefully the judge has some balls and admonishes the state for their bullshit. Wouldn't put it past Buckaloo to file another appeal because she can't handle losing. It's only going to hurt the state's case. Incredible. I'm loving that tweet. That's pretty much what I was thinking here. How is it going to impede the investigation, and how can evidence be destroyed if it's being handed over to the fucking judge? This is ridiculous. So what's the repercussions of the search warrant not being handed over? Shout out Bryson Paul. These are all his tweets, by the way. It's a motion, so I don't believe there's no repercussion for it. It's just up to the judge to rule. Sounds like Fulton County DA. They want her off the case bad. Wow. Turn the search warrant over. Ignoring court orders by the state. Color me shocked. Big slap in the face. I mean, yeah, everyone is pretty much saying what I was saying. I didn't even know that there was discussion about any of this. Okay, I've got it. The law is what the prosecutors say it is. Your rights are what the prosecutors say they are. Under our Constitution, judges are optional. An order by the judge is optional to the DA. Got you. Yeah, I would imagine the judge is going to be very pissed about this, and I can't wait to see what he says. That's the latest update for Melly. Quick little update. We'll see what happens. Hit subscribe. Love you guys. Peace out.